let's kind of switch gears for a minute if I can, John, because I want you to talk about this because you're the civil guy.
Sure.
Can you talk a little bit about the difference of the pretrial process, filing a lawsuit versus having to answer to one, quote unquote, with a criminal case, and what are the differences there in your estimation?
Obviously the differences are civil side. We are the ones running the litigation, right? We file the complaint. We serve the process. We get it going. We're the ones anxious to go to trial. We're driving the litigation home. Obviously on the criminal side, the government is the one that has filed the case, so to speak. They filed charges, whether that be by information or I don't know what the other one is, but Keela will tell me. Indictment.
Well,
see, she's going to correct me. Tell me, correct me. Go ahead.
No, I mean, it's not really a correction, but charges can be filed if it's a misdemeanor through a form or a citation or, information or indictment for like felonies, but it's, okay. I'm being picky.
No, it's okay. Correct me. I am humbled in any respect. But no, so obviously in that respect, and then obviously there's discovery that's conducted. What's interesting that I found about discovery is, depositions that are taken. Sometimes you're not allowed to take depositions. You're like they're doing a hallway where you're just like talking to a cop outside before. Like that's insane to me.
Yeah.
And let's be real. There's some jurisdictions around the country. I know I've spoken to colleagues. They don't even get that luxury.
Mm-hmm.
Yeah.
Sometimes they're flying in the dark.
And obviously in federal court it's extremely different. You don't like here's your case. You don't get to know anything. And by the way, you're going to trial and facing the rest of your life. So that to me, I think it seems to me, which is kind of opposite of the way it should be, is because you have those risks of your liberty, you should have more access to information, right? In a civil sense, you have access to information. You can file motions to compel. You can go after. You can take and depose anybody you want to, and to not be afforded that same time when, like, look, I have the risk of going to jail, and I can't do this, or I have to show a good reason why. How about they were involved in the case and I want to talk to them under oath, and so that to me is strange.
Well, I think in both settings, you're reliant upon the opposing party to produce or make available the information that you need. And there's a variety of tools that you can use to try and get it, right? There's criminal rules of procedure and civil in each, state, federal, and is the same. But what's different is that when it's criminal, the repercussions for the government for noncompliance is far greater. I mean, the Constitution is behind it, right? Brady versus Maryland and its progeny. I mean, there are serious consequences, convictions being overturned if there's prosecutorial misconduct, even when it comes down to discovery. So that affirmative obligation to disclose and make transparent everything is a lot more forceful in criminal, in my experience. Whereas in civil, one of the most frustrating parts of civil is it's cat and mouse all the time. Sometimes you go against a defendant. It doesn't have to be a corporate defendant, but it feels like, is this everything that's responsive? It doesn't seem like it should be. And you get it is. And then you got to fight motions to compel. And even when there's a wrong in discovery in the civil context, Keela, I don't know how you feel. It's like the remedy is not really as strong as it should be, right? Sanctions aren't brought down when I think that they should be, when something is egregious. And at the end of the day, you can be pretty handcuffed trying a case in civil court, because during the pretrial process and discovery, you have to fight tooth and nail for discovery that might have been incomplete.
But let me ask you guys this question. How do you know that you talk about this affirmative obligation and we hear like, oh, convictions are being overturned, which means they're withholding evidence. How do you know? How do you know that they're complying with affirmative obligation and then people are going to prison and then they find out about, 10 years later they had this information, this is exculpatory information that they have to fight to find, and then they're out. Well, I've already lost 10 years of my life. How do you know, Keela, that they're even fulfilling this affirmative obligation? Like, how do you know?
Well, you don't. You really don't. You have to really, as a criminal defense attorney, you have to do an investigation as well. You can't just rely on the government to provide you with evidence of your client's innocence, right? Like, as soon as you get a case, you need to do an investigation. You need to talk to witnesses. You need to canvass the area to see if there is any surveillance. You need to do these things because you can't 100%, believe that, they're turning everything over. Now, it might be purposeful, right? That's
nobody wants to think that there's
right.
going to be intentional
right.
misconduct.
Some people, you have good and bad attorneys, right? So, some attorneys, they purposefully do it. Sometimes they just don't have it. Right. They should, because, depending on the law, I'm not going to get too much into it, but what the police officers gather during their investigation is what the government, the prosecutor, should be giving over to us. Sometimes there's this disconnect between what the officers have in their possession and what the prosecutors have. But to kind of piggyback off of something Jordan said about like the cat and mouse game, I think that although there are sanctions and different remedies that you can get in civil, and then in criminal you have Brady and all the law, the force of the Constitution behind you, I always felt like it was a cat and mouse game getting the government to give me discovery. That's why it was important for me to use, the right to a speedy trial to my advantage or to my client's advantage, because I'm filing my motion to get the discovery. I'm looking at that, 30th day or that 16th day. I'm filing motions to compel. But when you get in front of the court, sometimes the court can be very lenient towards the state, the government, and say, well, we'll reset this and give them time to get you the discovery that you should have had 2 months ago. And now your client is sitting in custody, waiting for trial. Or what I think is really undervalued is your client is out of custody waiting for trial.
Right.
Someone who is facing criminal charges, whether they are out of custody or in custody, they have the weight of incarceration hanging over their heads, and that's heavy for them and their family, and it's just overlooked.
Well, did you guys, you both worked at the public defender's office. This may be a simple question, but were you guys afforded the same resources as the state?
Well, no, technically both sides are state employees, but it sure didn't feel like that.
Right.
And that, by the way, through no fault of Carlos Martinez, the public defender in Miami, and everybody else down there, man, everybody does the best that they can with the available resources, but it never felt like, even Steven, I don't know about you, Keel, it always felt like I was pushing a boulder uphill to get anything, Yeah. There are limited resources. Look, that's the reality. Mm-hmm. Keel, you mentioned something interesting. You said the right to speedy trial. I don't want to dovetail into a substantive lecture, but that's my biggest pet peeve. John's heard me complain for years about it. In the criminal context, there is a degree of control. I'm hesitant to use that word, but I think it fits, where if your client's out of custody and facing serious charges, and maybe there's a lot of other life circumstances that you want to drag your feet, you don't have to file a speedy demand. Conversely, if there's a benefit strategically to pushing the government to the brink of trial and trying a case sooner than later and not letting your client languish, or maybe he or she's in custody and really wants a resolution, you can file that speedy demand, and you can put a clock on the government, and come hell or high water, you know when you're going to be in trial. When you come to the civil game, first couple of years, John was like, what is your problem, dude? Just be patient. It's like, I don't want to be patient. I want to go. I'm ready for trial. I'm ready. I want to try this case to verdict. And it's a game of hurry up and wait. Now, federal court's a little different. You file a case pretty soon thereafter, you're getting a scheduling order with a trial date. But in civil, even when you get a trial date, in state court rather, it feels like it can be continued indefinitely. And I miss that lack of control for the clients,
It's so slow. That was a big transition for me, because in criminal, when we're at the PD's office, it's fast, but it doesn't feel that way. You know what I mean? Like, I can file a motion to compel on Monday, and I can have it on calendar on Wednesday, and the judge can say, well, 15 days to get you this discovery. And it just feels like forever. When you go to trial, or you set for trial and you say March 1st, you're set for trial, you come March 1st to trial, and it's reset to April 1st. I'm losing my mind. I'm losing my mind with my client. It feels so slow. And then you come over to civil and you learn patience. I'm still getting used to it. I'm still getting used to how slow it is, because you receive a motion, and Jordan and John, you guys do it way more and faster. But you get a motion, you reply real fast, and you're into it, and you're putting all of your cool stuff in it, and you're ready to argue this motion. And then you argue it 4 months later. It's like, what? Yeah. Things getting on judges' calendars in civil, it takes so long because of the backlog. It's no fault of the judges at all. It's just so slow.
Yeah, and I think that what we've seen is that the Supreme Court, with the work group and what they're doing, is they're kind of really recognizing that. Good luck getting a continuance anymore if these rules are in effect. they're changing and putting in place that rules say that when you file a motion, they don't even need a hearing anymore, right? They could rule. The problem is I don't think that the judges have the resources like federal court to handle that. They don't got 6 law clerks, 2 permanent, 1 temporary, 3 in school. You know what I mean? But that's going to be the expectation, is that you file a motion and it has to be set within 30 days.
Yeah.
You write to. So I think that they're looking at it as they want to streamline this. They don't want this lengthy delay, and part of which is we do have the backlog. We got shut down for what?
Yeah.
18 months or
Right.
6 to 15 months of trial. And we've been fortunate to have, since COVID's come back, we've tried 5 cases, and so we want to keep this going. We want to keep this energy. We want to, myself and Jordan, we're trying to case May 2nd up in Gainesville, Florida. I mean, that's our next trial. I mean, we're going. We got the confirmation, and it's happening. And so we're fortunate to try to push, but all we can do is try to, keep pressing, keep pushing, keep filing, keep doing what we can, opposing continuances, and just push, because delay benefits defendants. Not
you're dancing on the razor's edge, right? When we're doing that, we don't want to concede any issues unnecessarily, but I think this is a good, kind of final topic here on the pretrial, which is to say, in criminal, I think both sides, one thing that they have in common is they want to make sure they're prepared. And then at some point, both sides just want a resolution, whether it's going to settle out or try it. The government needs to clear their docket. And in the criminal sense, the client you have wants a resolution. So there's some kind of commonality of interest there. The civil side, even if it's only my perception, it's all I see. I feel like in the pretrial stage, that is where the defense attorneys want to live and die and stretch out as long as possible at times. And, I'm not suggesting everybody's doing this, or that sometimes there's not very legitimate reasons to stretch out the pretrial discovery process. But heavens, it feels at times like, okay, I wasn't sure how you were billing, but now I know for sure you bill by the hour, because depositions, right? Sometimes 30 minutes into a depo, we haven't even talked about what happened. That doesn't happen in criminal cases. Never. Tell me where you went to high school and where your auntie lives, and these things that don't matter. And that is maddening for me, because that builds in the delay, and we're not getting paid for our time. Not that we have to make the most efficient use of it. I mean, at the end of the day, some things you can't, but I don't like that lack of control, where sometimes the defense can make a position or posture and tell the court, no, I need X, Y, and Z, and we can't go forward until I get it. And sometimes the courts are willing to accommodate it. So John, to your point, I hope that when the rules do change, if and when they do, that those things change. But I don't know, do you guys feel the same frustration with discovery, that sometimes it feels like it goes on indefinitely?
Yes.
Yeah.
Yeah.
I mean,
that's most of
frustrating.
it. It's just discovery.
Yeah. And I thoroughly despise discovery. Not in the sense.
How about, John, come on, I know you love when you serve in Florida. We have some Florida Supreme Court approved interrogatories that you're supposed to serve out of the gate. These are approved by our Supreme Court. We send them. John, how often are you getting objections or incomplete
every
answers
time,
to them?
man, every time. I mean, that's the thing. What becomes frustrating about discovery is it's the same fights on the same issues that have to go in front of the and I keep winning, and it's like at some point, and another change that's coming is big sanctions. They're going to be sanctioning you for everything. If you breathe incorrectly, you're going to get sanctioned. I mean, I don't mean that literally, but I'm just saying there's now going to be specific rules of civil procedure for just sanctions, and I think that the way you effectuate change is by holding people accountable.
Yeah,
and look, I don't profess to be the best at discovery, and a lot of times I'm late. I do my best, and because we see that the discovery, the reason why it's so important is because they use it against your client. So it has to be correct. It has to be thorough. It has to be, correct. And we don't object. I don't really, I mean, we object to some things, but the majority of it, I answer. We're the open book. I want I'm all about transparency and clarity, maintaining that credibility, especially with the court, because so they don't come on motions to compel on, positions, or if they do, I have a very good legitimate reason with case citational support,
Yeah. I think one of the biggest differences with the discovery in criminal and civil is, on civil it's a lot of discovery on the paper. These interrogatories we're talking about, you just ask the question and the other side is answering under oath, whereas in criminal, even if you're participating as the criminal defense attorney in reciprocal discovery, it's not on paper. No one's sending you questions for your client to answer under oath. You're not sending the government or the whoever is harmed questions under oath. Like, it's depositions and trial. It's papers in the form of, like, if there's police reports and affidavits, and if it's a paper crime, all the checks and all the things. But that is one of the biggest differences I saw when it comes to pretrial and from criminal to civil, is everything is on paper. You don't have to take all the depositions because you have written questions under oath, and it's definitely more open. The information is more.
I think that's a really salient point, which is, in the criminal context, you're never going to have a case where your client is the tool of discovery. I mean,
right.
They may have given a statement before they got involved with you, but they're never going to be the source of information for your opposition to leverage. Conversely, you're never going to have a plaintiff that isn't a tool of discovery, that won't be deposed, that won't be answering questions under oath and interrogatories. And that's a huge difference. So, we can have conversations with clients that are being charged with a crime, and all that stuff is attorney-client privileged. And, whether we want to use it or not, it's kind of a strategic filter that we have. We don't have that. So there's a lot more. And John is the best I've seen at this. John is going to copiously read every single medical record historically that our client had, prep the client on everything. When push comes to shove and that client is being asked questions under oath in a deposition, he or she is able to tell their truth, but without tripping over their own two, giving the other side something that they don't necessarily need. Now, John.